Welcome everyone to Podcast 69 South, where we cuss and discuss true crime, cold cases, current events, and hot topics, along with our state of society today. This is your trigger warning. Our podcast content is produced for adult listeners 18 years of age and older. We discuss situations that may be offensive and triggering to some listeners. Sit back, relax, and enjoy. Welcome back, everybody, to Podcast 69 South, and I am Chop, your host, and with me always is my beautiful co-host, Julie. How are you today?
I'm good.
But we've had some nasty, shitty weather out here.
Oh, it's been horrible.
Yeah, did a lot of snow plowing, a lot of snow.
I know the phone wouldn't stop ringing. It was just da-dun, da-da, da-da.
It was like Groundhog's Day on the tractor plowing snow for people. Gained a lot of listeners, though, because I talked about it, but it was just like nonstop.
Yeah, that's exciting. I bet it wasn't too exciting, though, on like the 16th hour.
No, and it wasn't exciting when I couldn't stop shaking at 10 o'clock doing my last driveway. And then the nice lady said, "Oh, I forgot to tell you, my mom's is across the street. We need it plowed too," after I loaded everything up and shit.
But those are blessings.
Blessings. We was glad to help people, and it was some really needed work. This is part 3 of the Richard Allen appeal case. We're going to get into some real interesting shit on this episode, so stay tuned and pay attention. We're going to jump right into it. This is basically the summary of argument in the appeal paperwork, and the first part of it is the unconstitutional search. The trial court committed reversible error by admitting evidence seized under an unconstitutional warrant and by denying Allen a Franks hearing. Detective Liggett obtained the warrant for Allen's home only by omitting and altering witness descriptions to connect Allen to Bridge Guy, and by misrepresenting that Allen admitted he wore a blue Carhartt like Bridge Guy. These misrepresentations and omissions misled the judge into believing multiple witnesses saw Allen and his car, when in fact they described someone else and a different car. Once the affidavit is corrected, there's no probable cause. So that means that it's basically poison fruits of an unconstitutional search, like you've explained several times.
That manner.
Right.
So their next argument was unprecedented confinement. Allen's confessions were involuntary and the product of grave mental disability caused by 13 months of maximum security pretrial solitary confinement, which exceeded Indiana Department of Corrections policy and caused psychosis, paranoia, and confusion while state actors were indifferent to his deterioration. Admissions of these statements violated both federal due process and Indiana's protections against unnecessary rigor, and the error was not harmless, requiring suppression.
And this is where they talk about the unfair trial. The trial court denied Allen his constitutional right to a fair trial through a series of arbitrary and prejudicial rulings that crippled his ability to present a complete defense. The trial court excluded critical exculpatory evidence, including Blair's sketch, which directly undermined the state's eyewitness theory and timeline, and barred expert testimony challenging the reliability of the state's forensic methodology. It permitted inadmissible hearsay to rehabilitate the prosecution's timeline, and it blocked Allen from presenting evidence that showed the circumstances that led to his confessions and impeached their credibility, including audio depicting his deteriorated mental state. The court further prevented Allen from introducing substantial evidence of third-party guilt and an incomplete investigation, depriving the jury of context necessary to assess reasonable doubt. Collectively, these errors violated Allen's 14th and 6th Amendment rights and created a fundamental one-sided proceeding. A new trial is constitutionally required to restore the integrity of the adversarial process. I have to agree with that 100%.
So their main points are the unconstitutional search,
right,
the unprecedented confinement, the unfair trial, and they go a little bit deeper into those arguments. Now, for the trial court, they feel that the trial court committed reversible error by admitting evidence seized from the unconstitutional search of Allen's home and denying a Franks hearing. When reviewing the admission of evidence after denial of a motion to suppress, the court considers evidence favorable to the ruling and uncontradicted evidence to the contrary. Factual findings are reviewed for clear error, but the constitutionality of a search is reviewed reviewed de novo. Allen filed a motion to suppress, a motion for a Franks hearing, amended request, and a lengthy memorandum with exhibits. The trial court denied the motion and hearing, concluding Liggett's affidavit did not include false statements or omit facts with reckless disregard or intent to mislead.
I just want to say something real quick. Does it matter if the intent, you know what I mean? If his intent wasn't to be shady, but it was bullshit, shouldn't they? I would rule it out.
They should put exactly the information they had, even.
I mean, if a
If they
cop
thought
drops a bag of dope in your floor and you get busted for the dope,
Yeah.
they can't go back and say, well, the cop didn't mean to drop the dope. You know what I'm saying? If his intent wasn't to plant the dope, he accidentally dropped the dope in your house and you got charged with it. They're saying that, well, we're not going to go back and redo the search warrant because the cop's intent on the probable cause affidavit
was to get a search warrant.
Right.
The intent was to get a search warrant.
Exactly. Anyway, so the trial court erred by concluding Detective Liggett did not make false statements or reckless omissions in his affidavit. Both the state and U.S. Constitution guarantee that, quote, no warrants shall issue but upon probable cause, supported by oath or affirmation.
Affirmation.
That's what I meant, baby. U.S. Constitution, amend 4 Art 1 and 2. The state must include all material facts in a warrant application, including facts that cast doubt on the evidence of probable cause and a, quote, source's reliability. And a warrant is invalid if, 1, the police omitted facts with the intent to make the affidavit misleading or with reckless disregard for whether it would be misleading, and 2, the affidavit supplemented with the omitted information would have been sufficient to support a finding of probable cause. The defendant must prove a reckless or deliberate false statement by a preponderance. An officer omits evidence with reckless disregard if the officer withholds a fact in his ken that any reasonable person would have known that the judge would wish to know. Examples include facts undermining the type of drug seized or an informant's reliability. This includes details undermining an officer's conclusion, like marijuana field officer described as near defendant's house was 2 to 6 miles away. You see where that's kind of a little bit misleading. There was a pot plant
near somebody.
miles
you think
away,
near somebody's house. You're
and
thinking
back porch,
or within 20 foot of his house or something.
Now, see, I didn't read this when I was talking earlier, but that's exactly what I was talking about right there. You find a pot plant near a dude, exactly, and it's the intent of the wording.
So what the defense is saying is that the detective misled the court by incorrectly reporting witnesses' description of suspects or equating that description with the defendant, Richard Allen. They say that Detective Liggett omitted and changed key information that undermined his conclusion Allen was bridge guy. Liggett misled the court in 4 ways. First, Liggett misled the court to believe Blair's description of the man on the bridge matched Allen when it did not. Liggett told the court that Blair said the man was standing on the platform and wearing a blue jacket and jeans. But Liggett omitted the rest of Blair's description that did not match Allen. The man had brown, poofy hair like the sketch they provided, which was, I believe, the very first sketch that came out.
It was the first sketch, and if you look at it, it looks like a young dude in his 20s and 30s.
Youthful, medium build.
Exactly. Nothing like Richard Allen at all. I mean, it's crazy.
Second, Liggett misled the court that Allen's car was parked at the old CPS lot during the time of the kidnappings. Liggett told the court that after Blair saw the man on the bridge, she saw two girls she thought were Abby and Libby on the trail approaching the bridge. As Blair was leaving the trail, she saw a car oddly parked at the old CPS lot. Around 2:10 p.m., another witness, Wilson, also saw a car backed into the CPS lot as if concealing the license plate. Both witnesses drew diagrams of the car parked in the same general area and manner. Liggett told the court that Allen parked his black 2016 Ford Focus at the old CPS building, but omitted that Blair said the car she saw during the time frame of the kidnapping was not black and had sharp angles.
And edges kind of like a old Granada or an old like a box Chevy or something. You know what I mean? Like an 80s,
Or a
70s.
Cutlass, the
Right.
older types. And that's a mass difference from a 2016 Ford Focus, which is, I think, more rounded.
Oh, absolutely. If you look at it, it looks like a little like
Egg
a
or
spaceship.
something.
Yeah, like an egg.
On its side.
It's not even on the same page. It ain't even in the same library, folks.
So, and then Blair excluded Allen's black hatchback. So it was not his car at all. Now, this is material omission. Example, invalid warrant where an officer changed witness's car description in drive-by shooting. So third, Liggett misled the court that the man walking on 300 North was Bridge Guy. Liggett falsely told the court that Carball in 2017 claimed the man was muddy and bloody wearing a blue jacket, and what she actually said is his jacket was tan and he was muddy. A bloody man in a blue jacket matches Bridge Guy. A muddy man in a tan jacket does not. Liggett also omitted that Blair told him that the man she saw on the bridge was not the same person Carball described. ISP even released a public statement. The men are not the same person. Fourth, Liggett connected Allen to Bridge Guy by falsely claiming Allen admitted wearing a black or blue Carhartt and a head covering. The man the four girls saw wore the same clothes as the man on Libby's phone. The clothes Allen admitted he wore matched the clothes by the individual on the bridge in the photo taken from the video on Libby's phone. But Allen told investigators he did not know what he was wearing. Although Liggett used Allen's wife's statement that Allen currently owned a blue Carhartt as a nexus to his home, Liggett omitted that she said he purchased his coat a couple of years ago. The girls were killed in 2017. Had the court known Allen simply admitting owning a blue or black coat, as does probably every 50-year-old man, it would have known there is no connection between him and Bridge Guy.
You do have to admit that is some bullshit. You got the car that he completely changed the description of, changed the witnesses' statements on.
It was like putting a puzzle piece together, kind of.
Yeah, and chopping the circle off so it fits next to the other one. In the
like
puzzle.
taking a sentence from one witness statement and mixing it with a statement from the other, like copy and paste in certain sections to make it say what you want.
And just like she said that he bought a blue Carhartt jacket a couple years ago. Well, this was way more than just 2 years after the murders. It's just, I think we'd all be really surprised at how often this happens and these cases aren't dug into. A lot of police are good, but a lot of police use this shit on their probable cause affidavits. You know what I mean? They fudge this and fudge that, and it gets out of control. Somebody that doesn't have the public access and the, where it's being dug into.
But there's also officers who describe everything
To a T.
to a
Absolutely.
T exactly the way it happened. And I know also in probable cause, not all evidence is listed that they do have. They just put enough in there to get, the warrant for an arrest or a search warrant or things of that nature.
There's bad apples in every batch, unfortunately. There's a lot of good cops out there that would not sleep at night if they put a wrong punctuation in a probable cause affidavit to screw somebody. I know there is. But they're saying Detective Liggett's omissions and false statements recklessly misled the judge. Any reasonable person would have known the judge would wish to know that 1. Blair's description of Bridge Guy in the car at the CPS did not match Allen or his car. 2. In 2017, Carball described the man walking down the road as only muddy, wearing a tan jacket, not in a blue jacket like Bridge Guy. 3. Blair did not believe she saw the same man Carball saw. 4. Allen never said he wore a blue Carhartt or head covering like Bridge Guy, and he bought his blue Carhartt jacket a couple of years before 2022. The omitted and false information strikes at the heart of Liggett's conclusion that Allen was the man on Libby's phone. The state's probable cause relies on a tight timeline, making Allen the man the 4 girls saw on the trail, Blair saw on the bridge, and Carball saw on the road. Any judge would want to know if witnesses describe someone other than Allen, his car, or Bridge Guy. Moreover, the fact Liggett lied twice in the affidavit about the connection between Allen and Bridge Guy shows more than reckless disregard for the truth. These falsehoods were directed at connecting Allen to Libby's video, which would otherwise include any white male.
With the omitted and accurate evidence, the affidavit was insufficient to establish probable cause. Probable cause exists when there is sufficient evidence to cause a reasonably prudent person to believe a search will uncover evidence of a crime. A reasonably prudent person would not believe Allen was connected to the murders or that evidence would be found in his home. The state is left with Dolan's report claiming Allen told him he was on the trails between 1:30 p.m. and 3:30 p.m. and saw 3 girls, not 4 girls, like those who thought they saw Bridge Guy. During his October 13, 2022 interview, Allen admitted wearing blue jeans and owning a gun, knives, and a blue or black jacket, and walking out to the first platform of the bridge to watch fish. But Allen does not look anything like the person Blair saw on the bridge. Also, his car is a different color and the shape than the oddly parked car, and the man Carball saw walking was most likely not even Bridge Guy. If Allen being on the trail within the same 2 hours the girls were abducted is enough for a warrant, law enforcement would have obtained one for Allen's home in 2017. In 2022, ISP had no more evidence connecting Allen to the murders than they had days after the murders when Allen, like others, responded to their requests for help. It was not enough then, and it was not enough in 2022.
And it's not enough now, in my opinion. These errors requires reversal. A court must suppress fruits of an illegal search, and it states the constitutional Supreme Court hearing, the state's entire case is built on Liggett's half-truths and falsehoods. Without the gun seized in the search, there is no opinion from Oberg upon which the state arrested Allen. And without the arrest, there are no confessions. If the warrant was illegal, the state has no case. Even if this court finds the confession was not a product of solitary, Allen is still entitled to a new trial. Before a constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt. Without the fruits of a search, the gun, a casing in a hope box, the Carhartt, knives, and computer, the state cannot prove the jury would have convicted.
At minimum, Allen is entitled to remand for a Franks hearing, even if Allen's exhibits to the Franks motion did not prove by a preponderance that Liggett deliberately or recklessly falsified or omitted material information. They entitled him to a hearing. A defendant who makes a substantial preliminary showing that an affidavit included a false statement or reckless omission necessary to probable cause is constitutionally entitled to challenge the warrant at a hearing. To meet this showing, the defendant need not present conclusive proof but must support their accusations with evidence and citations to the warrant application. Here, the court's denial of a hearing was legally erroneous because Allen made a substantial showing. Allen supported his claims with depositions, police interviews, and reports, citing Liggett's application. Allen made specific arguments. In a final motion, Allen reiterated these points, urging the court to compare the affidavit with Blair's and Carball's interviews. Tellingly, the trial court was willing to schedule a Franks hearing when Allen was represented by Fort Wayne attorneys, but refused when the original attorneys were reinstated. Allen's constitutional protections are not contingent on who his attorneys are. Wow, that's crazy. I didn't know they said remember when his attorneys kind of got fired?
Yeah, I do. That was crazy. I do remember that. I forgot that actually.
I think it's because somebody took pictures off of
somebody leaked something out of their office, pictures out of their file cabinet or something. Yeah. So they were going to give him a Franks hearing.
Well, after those lawyers they got removed, and then he got a set of new lawyers from Fort Wayne.
Right.
And by this, it says that the trial court was willing to schedule a Franks hearing when Allen was represented by the Fort Wayne attorneys. But once the attorneys fought and they got back on his case, his prior attorneys, they were refused that same hearing.
Something smells real fishy there.
That's
I'm just
crazy.
saying. And folks, I know it sounds like we're going over this stuff, quite a few times, but it's important because everything that we're saying here is supported by Supreme Court judgments and
or cases that have went before them, and
right,
things like that. They're citing everything.
Yes, ma'am. They're citing all of it, and we went through and looked at these Supreme Court cases, and I mean, they're right. His rights were violated several times in this case.
Very much so.
The trial court erred by admitting statements Allen made while gravely disabled during his unprecedented pretrial solitary confinement in a maximum security prison. Quote, I found solitary confinement the most forbidding aspect of prison life. There is no end and no beginning. There is only one's mind, which can begin to play tricks. Was that a dream or did it really happen? One begins to question everything. That's actually a statement from Nelson Mandela.
Yeah, Nelson Mandela, he served 27 years in prison, and then after he came out, he won the Nobel Peace Prize, and then he became South Africa's first black president.
I've seen a lot of stuff that he's said, speech and stuff. He seemed like he was very intelligent, and so he knows what solitary confinement's like after 27 years of it. Good Lord. And I bet it does play tricks on your mind.
You know it has to.
Time is just...
sitting in a...
Oh, man.
5x7 cell, and all you're doing is sitting there looking at the wall?
Playing in poop and stuff and giving shots of your butt of Haldol and all that crap. It's horrible. Anyway, solitary confinement is a form of punishment, and depending on its condition, even torture. By 2023, when Allen was held in solitary for 13 months, it was well established that prolonged isolation causes psychological pain, suicidal ideation, and psychosis. To protect inmates from psychological harm, Indiana Department of Corrections strictly prohibits solitary confinement over 30 days for anyone with a serious mental illness, and requires transfer if the mental illness symptoms appear. When Allen exhibited the predictable symptoms of psychological pain, confusion, and psychosis, the Indiana Department of Corrections administrators refused to transfer him to a mental health unit. When Allen's attorneys informed the court of his dire condition, the court also refused to move him, and the prosecutor delayed and mocked counsel's concerns while collecting evidence of Allen's confessions. The question for this court is unprecedented but simple. Should the state be able to benefit from Allen's psychological pain that their deliberately indifference to his mental health caused? Human decency provides the answer, and it's no.
A standard of review and additional facts. An appellate court reviews a suppression denial for substantial evidence of probable value that supports the trial court's decision. It considers uncontradicted evidence favorable to the defendant and reviews legal issues de novo. This voluntariness of a confession is a legal issue. Allen moved to suppress his statements while made in solitary confinement, which the court denied. The court reasoned the statements were voluntary because Allen failed to show they resulted from the state psychological coercion or coercive interrogation. The court found Allen's detention was intended to protect him and that while he suffered from major depressive disorder and anxiety, he did not have a serious mental illness that would render his statements involuntary. In addition to Department of Corrections records and videos like those admitted at trial, Allen proffered an order and settlement from Indiana Protection and Advocacy versus the Indiana DOC that the trial court excluded from the suppression hearing as irrelevant. In 2011, the Southern District of Indiana held that Department of Corrections housing of seriously mentally ill inmates in solitary constituted cruel and unusual punishment, violating the Eighth Amendment. The Southern District found that serious mental illness includes delusional disorder, psychotic disorder, and massive depressive disorder. Segregation is harmful to prisoners with serious mental illness due to lack of social interaction, significant sensory deprivation, and forced idleness, leading to decompensation and psychological pain. An inmate decompensating from solitary may experience hallucinations, sleep disturbance, memory problems, anxiety, paranoia, depression, eating problems, or engaging in self-injury or suicide. Suicide Watch further exacerbates the illness. The severe conditions in the segregation units cause a predictable deterioration of seriously mentally ill prisoners' mental health, and the DOC has explicitly observed, diagnosed, and noted patients' decompensation. The Indiana DOC knew these effects occurred even with
After the holidays, there's so much to clean up and get ready for the coming year. This leaves me exhausted and a lot of things falling off my to-do list. It's time to lock in, and Omaha Steaks delivers everything you crave to reset after the holidays. An order from them means having high-quality Omaha steaks on hand at all times. I'm a big meat lover myself, and I always go with medium rare. But there's also plenty of poultry and other options available. Omaha Steaks offers unrivaled quality and variety, and every bite is backed by their 100% guarantee. A family-owned company with over 100 years of expertise in the meat industry. Let Omaha Steaks deliver high-quality proteins right to your door. Visit omahasteaks.com for 50% off site-wide during their end-of-season sale. And for an extra $35 off, use promo code YUM at checkout. That's OMAHA steaks.com, promo code YUM. Terms apply. See site for details. Go to www.omahasteaks.com to get 50% off site-wide during their end-of-season sale. And use promo code YUM at checkout for an extra $35 off. Minimum purchase may apply. Thanks to Omaha Steaks for sponsoring us.
SMI offenders.
Now, before a hearing on relief, the parties reached a settlement including an, quote, expanded definition of mental illness that subsumed the court's definition. The IDOC's policies refer to the settlement, which sets the tone. An inmate with a mental illness can only be held in solitary confinement for 30 days. If an inmate decompensates into a serious mental illness and is unlikely to return to general population within 30 days, a transfer is required. Allen admitted Dr. Westcott's 127-page report. 2023, Westcott evaluated Allen, who had been in Westfield Correctional over 9 months. He was terrified, unsure what was real, and wondering if he was dead, in hell, or waiting for heaven. He could not recall weeks of early 2023, including playing with feces, confessing, or banging his head. He believed that he had been drugged. Westcott cited the Department of Corrections records showing acute periods of confusion, paranoia, delusional thinking, cognitive slowing, aggression, and combativeness during this period of loss of, quote, touch with reality. Allen confessed. So he was, I could only imagine. You don't know
Right.
what's real. You don't know if you're dead. You don't know if you're waiting to go to hell or heaven.
Mm-hmm.
The dude literally had a normal life working at CVS, and then bam, you're in prison for murdering 2 girls and being, we don't know this for a fact, but you know the inmates were fucking with him non-stop.
Yeah, and then you hear these things and you think, man, if this guy really did do this to these girls or anybody who does this to any kids, you think, well, this is what they get. This is what they deserve. But what happens when they really may be innocent and they're having this happen to them? I can see them going even crazier than
Exactly.
the person who really did it.
I agree 100%. That makes me even think a little bit more swaying towards he didn't do it, because it's just he don't even know like what the F is going on. It's like,
And wouldn't you think that a person who really killed 2 young girls has a serious mental illness anyway?
well, yeah.
So I don't
I mean, that's
see-
not normal by any means.
No, not at all.
Westcott concluded Allen's psychosis stemmed from his major depressive disorder, his personality, and the well-known effects of solitary confinement. Allen was, quote, grossly disorganized, delusional, and paranoid. Objective testing ruled out malingering.
The trial court abused its discretion by refusing to admit the IPAS order settlement into the suppression hearing. Evidence is relevant if it has any tendency to make a fact of consequence in determining the action, more or less probable than it would be without it. Here, the order settlement makes it more likely Allen's psychosis was caused by his confinement. The order found solitary confinement causes all the symptoms Allen experienced. Allen was more likely to decompensate because he spent several months on suicide watch, an even more restrictive form of solitary confinement. The order also makes it more likely Allen was subjected to psychological coercion by showing solitary causes, psychological pain. It demonstrates state action, the Indiana Department of Correction placing and keeping Allen in solitary, knowing it was causing this predictable pain. The order shows how extensively Indiana Department of Correction violated its own policy, as it includes major depressive disorder in the SMI definition, restricting Allen's solitary to 30 days. Allen was harmed by the court's refusal to consider the order because it undermined the court's finding and conclusions.
They're saying that the state failed to prove Allen's statements while gravely disabled were voluntary. The U.S. Constitution is saying that the state failed to prove that Allen's statements were not a product of psychological coercion. An involuntary statement obtained through state action violates due process and is inadmissible. In 1986, Colorado versus Connolly, a confession is voluntary if it is a product of rational intellect and freely self-determination rather than overborne will by the state law enforcement conduct. State law enforcement can include psychiatric facilities and prison staff. Statements produced through a coercive environment are involuntary, regardless of whether solicited through police interrogation. United States versus Karaki in 2006 says months spent in solitary confinement, deprived of light, adequate food, and contact with the outside world is, by itself, sufficient to sustain a finding of involuntariness. There was a Supreme Court case in 1997 where a staff at a state psychiatric facility created a coercive environment, rendering a juvenile's confessions involuntary. The crucial element is police overreaching. When state actors use more subtle form of psychological coercion, the defendant's mental illness is more significant in the voluntariness determination. But the state must still exploit the defendant's illness with coercive tactics. This is generally done through aggressive interrogation, but exploitation can occur in other ways. It is difficult to imagine a situation in which a confession would be less the product of free intellect, less voluntary, than when brought about by a drug having the effect of, like, truth serum. For a statement to be involuntary, state action must be casually related to the confession. So
that wording right there, casually related to the confession. I can't imagine having to be the people who's writing these laws, because each word matters in its own way.
And we're not quoting all the Supreme Court cases because we would just keep going on and on and on forever. But
I'll post this on the Patreon if anybody wants to go read it.
yeah, and you know why lawyers, like you were saying earlier, to be the lawyer, to have to word all this stuff, have to quote each Supreme Court cases to prove your fact where the stuff has already been adjudicated in court. I bet lawyers that's been in the game for 20, 30 years, they probably have most of these memorized. Like, hey, that's blanky blank from New York, the state, versus
like
U.S.
in their certain niches,
Exactly.
But I bet there's so many. Could you imagine the research you have to do of these cases to find exactly what you're looking for?
Could you imagine 5 drunk lawyers sitting around laughing about Supreme Court cases and telling them all how they was, you know what I mean? I called
or
this
debating on it.
Yeah.
So the state's prolonged solitary confinement of Allen was state action. Contrary to the court's finding that Allen failed to prove state psychological coercion, it was the state's burden to prove Allen's statements voluntary by a preponderance of the evidence. To the extent Allen had a minimal burden of production, he met that. Prolonged maximum security solitary confinement of a pretrial detainee, especially after psychosis develops, is state action. Unlike the mentally ill defendant in Connolly, who walked into a police station and confessed, Allen never voluntarily came into custody. He consistently protested innocence until enduring 5 months of maximum security solitary with no human contact except while being chained or caged. Because it was pretrial, Allen's solitary was unprecedented and borderline, if not unconstitutional, punishment. Other Indiana Department of Correction safekeepers were in mental health units, not solitary. On a continuum of possible punishments in the justice system, solitary confinement in a maximum security facility is the most extreme. Also, Allen's solitary exceeded the 30-day Indiana Department of Correction policy restriction. DOC knew it could harm Allen. When DOC observed Allen's predictable deterioration, they refused to transfer him, keeping Allen in solitary when he was no doubt seriously mental ill with an administrative, not clinical decision. Finally, the state's conduct also involved the prosecutor, law enforcement, and the court. After Allen filed his April 5th emergency transfer motion citing his dire condition, the prosecutor waited 9 days to respond while investigators monitored real-time calls in which Allen confessed. During this delay, Allen continued deteriorating. The prosecutor then mocked defense concerns as colorful and dramatic, while the same day, Indiana DOC found Allen gravely disabled. Knowing Allen was decompensating, the court refused to transfer him, putting the onus on the Department of Corrections to provide care. It is fundamentally wrong to keep a gravely disabled Allen in solitary while using against him statements made to psychologists and suicide companions.
It's almost like, and I believe you said this earlier when we were discussing it, they were keeping him in there and torturing him and just waiting to get what they want.
It seems like they knew that he wasn't, I don't want to say weak-minded, but they exploited his vulnerabilities kind of, and knew that as soon as they put him in there and kept him in there for so long that he would eventually go crazy and start making any statement, which they didn't have enough evidence on one end. They knew that the statements would be like concrete, you know?
Right. And all the statements that he was making was insane. I mean, literally insane. He was saying that he molested a couple of family members, which they said he's never even touched us. That's bullshit. They were like, that's complete bullshit. He didn't even know if he was in heaven or he was in hell. I mean, he said all kinds of shit, but they just took one little piece of the crazy shit he said and used it against him. And the dude was definitely, that's torture on anybody.
Well, it was more than one little piece. He made multiple confessions. But, I mean, even you could see where he is going crazy and he starts making these confessions and his lawyer goes to file this emergency hearing. The prosecutor delays and waits 9 days. So in that time, they're like, oh, he's really going crazy. We're going to put the brakes on for a minute and wait to respond to this motion or this.
Right.
So they get 9 days of collected phone calls and everything that he's saying when he's completely out of his mind.
I wonder if the prosecutor and the psychologist that was in there that was listening to all the podcast every day, dogging Allen and all this shit, I wonder if they were like in cahoots more than what we would think. You know what I mean? Like
friends.
Yeah, I mean, like if the prosecutor was like telling the psychologist, you know what I mean?
I would hope not.
Tell him he did it. We know you did it. We got all the evidence on you. You did it. And then they're giving him Halidol and all these crazy medications. It had to be just psychological hell.
Well, we'll never know because she deleted all her notes.
Yeah, she sure did.
Entered them into the record. You would think you would want to keep all of that stuff. But 1 week later, the prosecutor saw all medical records, videos, and communications while confessions were ongoing. Monitoring and collecting his statements consumed hundreds of hours and produced over 60 confessions.
Wow.
Indiana State Police interviewed inmates and guards and even sent a psychologist to speak with Dr. Walla. Allen showed more than sufficient state action.
Wow, over 60 confessions they had recorded.
Yeah, I was even wrong. I knew it was a lot, but I didn't realize it was that much. And I can completely understand, you know, if you're sitting in a courtroom, I mean, the jurors only know what's put in front of them. You know? If they're not seeing evidence of this guy's been locked up in solitary confinement and he is losing his mind, but they don't know certain aspects of that and it's being presented to him like he's of legal sound mind.
And just confession.
They're going to vote guilty. You know, they're going. I just because I've read into this case and I've seen how some things were done, I can't even be mad at the jurors because they were. If I was a juror, I probably would have voted guilty if I didn't have all the evidence presented before me the correct way.
And they sure didn't have all the evidence presented to them the correct way. That's the point. You know,
and that's what they're saying.
That's what this whole appeal is about. And you know, I don't know if the dude's guilty or not, but I do know that in my eyes, I don't see a trial that, for one, this trial was screwed up pretty bad, I have to say. And the state prolonged pretrial solitary confinement was psychological coercion.
Yeah.
Allen's solitary was psychological coercion because it was prolonged, caused psychological pain, and put him at the mercy of the state. The prolonged nature is coercion because solitary confinement can bring a person to the edge of madness, perhaps to madness in itself. This has been recognized in literature, law, and science. They're saying solitary confinement causes psychological trauma, including psychosis, hallucinations, and paranoia. From day one at Westfield Correctional Unit, Allen was placed in a strip cell, the most restrictive cell in the most restrictive solitary confinement unit, with only bare essentials and a camera constantly recording him. Soon thereafter, DOC ordered guards to videotape him when out of the cell, including showering and his attorney visits. Suicide companions remained outside his door, documenting everything, regardless of suicide watch status. He had no contact with anyone unless caged or chained.
I have to say, this suicide companion thing just blows my mind because I can't see. You're in the worst of the worst prisons in Indiana, and their suicide companions were other inmates, right?
Yeah, I think in my mind it's just another inmate.
What if this suicide companion's writing down whatever he wants so he can be like, oh, yeah, this, and it helps him with his case.
Right.
Because he's saying, oh, well, I'm going to say Richard Allen said this, and maybe it'll help me get out of this. That's just how my mind works.
Yeah.
I don't know if that's how it really works, but that's what my mind would assume.
Yeah, I mean, I'm thinking the same way. I'm with you. What if, suicide watch companions, I mean, maybe they get special treatment. I think they're not in the cell with
Are they
him.
trustees of the jail?
Some kind of trustee like that, but I think they sit outside of his cell
And
and
talk to
watch him and talk to him, and you know what I mean? But, they're probably inmates that have not been in a lot of trouble. They're not probably the hardest dudes in there, you know
But
what
they're
I mean?
at Westfield. It's
They're at Westfield, right.
maximum security.
But I'm sure you have to have some kind of good rapport to be a suicide companion. They're not going to put somebody that just stabbed a guard or killed, you know what I mean? It's probably somebody with a good rapport in the prison as he's been there. But what I'm saying is the hard guys in there can get to any of the soft dudes, you know what I mean? And also the prison guards and also the prosecution team. It's just all tied together. It just makes you wonder.
I haven't heard anybody come forward saying, hey, I was in Westville when Richard Allen was there. I seen that this was going on, or I heard this. I haven't heard of anybody at all, like, who was inmates down there coming out and telling stories of their experience.
There was a guy that wrote a letter that was in there with him saying that he was being tortured and all that shit.
Oh, I didn't see that.
Yeah,
there's so much information,
It's unbelievable.
You retain it, and sometimes some of it goes, and you got to go back and find what you're looking for.
The sensory deprivation, social isolation, and forced idleness is difficult for even healthy people. Memory distrust syndrome, confabulation, and false confession. A healthy man wrongfully implicated and detained in solitary questioned his memory and suspected he committed a crime, though he stayed sane by reading, exercising, and praying. The experience traumatized him. Early videos show Allen pacing his 8.5 foot by 12.5 foot cell, laying down, doing leg crunches, writing, reading, and looking distressed. Cell videos. Within 2 weeks, Allen said he was broken and told his wife, if this becomes too much for you, call the detectives and I will tell them whatever they want to know. Had Allen's solitary been 30 or even 90 days, he would not have been decompensated. But it was 13 months. The prolonged solitary caused Allen predictable psychological pain, paranoia, nightmares, memory problems, and confusion. It is undisputed Allen deteriorated to being, quote, gravely disabled and, quote, very psychotic, and the DOC involuntarily administered antipsychotics between April and late June. Although Dr. Waller noted concerns about fiending, she diagnosed psychosis and suspected incompetence and over-medication.
Westville Correctional Unit only monitored Allen's mental health. Talking with a psychologist while shackled in a cage is not treatment. Solitary put Allen in a constant state of vulnerability. Solitary confinement has long been recognized as psychology coercive, equated to the rack and thumbscrew and protracted questioning. Pretrial solitary is punishment already underway and conveys, without the necessity of spoken words, the implied threat of further punishment. It does not matter why a defendant was in solitary confinement, whether justified or whether the prison planned for further punishment. In this harsh environment, Dr. Waller controlled all aspects of Allen's life, including whether he got bedding, clothes, meal items, books, personal items, and utensils. She could provide a new window and a tablet or strip him to bare necessities. Privileges were contingent on pleasing her. Whether Waller had ill intent is irrelevant. It is what Allen thought and what solitary confinement did to him or would do to many of us. After confessing to Dr. Waller on May 3rd, he asked for his property back, and she indicated she needed more consistency.
So that's just crazy. I got to stop you right there. So this psychologist that was controlling everything also controlled what shit he was allowed to have in his cell. Like, it's...
I'm surprised they didn't have 2 or 3 different psychologists working with them to get like you know what I mean? Like
Absolutely. Well, the thing is, it seems like to me, reading this, the way these lawyers are spelling this out, it's almost like she needs more consistent confessions. And, here's you can have your tablet back. Here's a blanket. Here's a pillow. Here's extra food. That just blows my mind. That just doesn't seem right in my mind.
Senator McCain, a prison camp survivor, explained solitary confinement crushes your spirit and weakens your resistance more effectively than any other form of mistreatment. Allen entered solitary confinement compromised. He left broken. Allen's confessions were a product of solitary-induced psychosis, not rational intellect. Indiana Department of Correction records show that Allen continued to suffer from psychotic episodes during the times he confessed. On April 5th, when he confessed to Dr. Waller, he was not eating or sleeping and was drinking from the toilet. On May 3rd, when he confessed, Allen had symptoms of paranoia and disorientation. Despite Waller claiming he presented as more organized than he has ever been. The day before, he was confusing nightmares with reality and claiming to have started World War III. 2 days before, he was too disjointed to hold a conversation. Days earlier, he covered himself in feces and claimed he was King Michael. His confessions to guards occurred during bizarre and psychotic behavior. Guards believed he was faking, but they are not clinicians, and Dr. Westcott found no malingering through objective testing. Allen confessed to his family on April 3rd, May 10th, May 17th, May 25th, and June 11th. On April 3rd, he also fell on the floor, asked if he was dead, and was suicidal. On May 10th, he believed he was dead, that the world would blow up if he slept, his water was poisoned, and he was reliving the same day. On May 17th, he was paranoid of attorneys and staff with Odin patches. On May 25th, Allen paced for 2 hours and banged his head. On June 11th, he thought he was in hell and did not understand what was happening. In August, Allen did not remember confessing or weeks of early April. Throughout, he complained of memory loss. State action overbore Allen's will. Allen did not confess until after 5 to 7 months of solitary confinement. Before the arrest, he consistently denied involvement. Dr. Westcott opined Allen's psychosis was caused by stress of solitary confinement on pre-existing illness. Dr. Waller agreed that a lot of time in solitary confinement exacerbates mental illness, and it is reasonable to believe Allen's confinement caused his psychosis. The social isolation of solitary makes people question their self. If you are treated like you are guilty, you begin to think you are. Dr. Gracian testified a false memory starts with a belief. In his first confession to his wife, Allen said, "I think I did it." In his first confessions to Dr. Waller, he was unsure if he had sex with the girls. Allen got facts wrong and confessed to crimes he did not commit. Allen claimed that he shot the girls.
It looks like we're running out of time for episode 3 on Richard Allen's appeal. But earlier in the episode, we were wanting to know if anybody had reached out in the prison while he was in there. And Julie, the investigator, found some unsealed letters right from one of the guys that was right there in the same unit with Richard Allen. We're going to start episode 4 of the Richard Allen appeal series with those letters, so you got to jump right to it if you got time. We're going to jump off here for now. We love all of y'all. If you want to support what we do, please go to
www.patreon.com/69south.
Have a good day, good evening, whatever, man.